Can you sue a school? A school or school district can be sued. Parents put a lot of faith in schools to not only educate children, but treat them fairly and with due care. It is extremely upsetting for parents to learn that their child has been hurt, mistreated, neglected, or harassed at school, especially when complaints go unaddressed. If your child has been harmed by the actions of a teacher, coach, administrator, or another student, and your personal attempts at resolution have failed, it may be time to consult an experienced California education attorney so that you can explore your legal options. Likewise, if you are a school employee who has been wrongfully terminated, or if you have any other legal issue relating to your employment, consulting an education lawyer may be necessary to ensure your rights are recognized and protected. Can you sue a school? Can you sue a school? Yes, you can sue a school, but understand that it is a complex process and can be a bit of an uphill climb. This is largely because public schools and certain private schools receiving government funding enjoy legal immunity from certain types of lawsuits. The California Tort Claims Act lays out very specific rules and requirements for bringing a lawsuit against a public school, and they must be adhered to very closely, or judges will be quick to dismiss the case. This is why it is so important to consult an experienced education attorney as soon as possible after an incident of wrongdoing. They can advise you on how best to phrase and frame your complaint, as well as when and how to do so. Can you sue a public school? Yes. Because of sovereign immunity laws, public schools are generally immune from legal liability for injuries caused by them or their employees. But this is not always true in practice, depending on the facts of your case. Before you can bring a lawsuit, you will need to go through the mandated complaint process with the school district itself. But you should always consult a lawyer before doing so, because in California, your formal written complaint to the school must include all possible legal theories you intended to argue later in court. If it's not in the initial complaint, it won't be legally admissible. Can you sue a private or independent school? Yes. If a private or independent school does not receive government funding, it does not enjoy the same types of legal protections as a public school, and the scope of liability for civil, personal injury claims is much greater. And though private schools are subject to less government regulation and intervention, they still have a legal duty of care to provide a safe environment for students. Many lawsuits against private schools are filed for the same reasons as those filed against public schools, and there are fewer barriers to bringing litigation. Issues unique to private schools, such as admission and tuition disputes, may provide other causes of action. Which attorneys sue school districts? To sue a school district, you will want to find an attorney in your area who specializes in education law or child personal injury law. Be sure to select counsel with plenty of experience handling lawsuits against public institutions, as the law tends to side with the school district by default, and there are very specific and specialized procedures for filing these claims. Even the smallest substantive or procedural error in doing so can result in a dismissal of your case. So retain an attorney who has a proven track record of wins in government and education litigation. Can a parent sue a school district? Yes. Parents and guardians are the most common initiators of lawsuits against schools. Oftentimes, parents have tried everything in their power to resolve an ongoing issue, and proceeding to legal action becomes their last resort. Common reasons parents sue school districts are when their child has been neglected, bullied, assaulted, discriminated against, injured, or sexually harassed at school. Other causes of action may include failures to provide or implement an individualized education plan, or make other accommodations for special needs students as required by law. Can a student sue a school district? A student may sue a school district if they are over 18, but as long as they are a minor, they generally cannot do so on their own. Federal and California state law effectively bars minors from filing lawsuits because they lack the capacity to enter into contracts, hire legal counsel, and sign court documents. While minor students can file an official complaint with the school district, any student under 18 wishing to actually sue the school or school district will need to have a parent or legal guardian acting on their behalf. Can you sue a school district for bullying? Yes. If your child is being bullied at school and teachers and administrators see it but are doing nothing to stop it, the school district may be liable. Likewise, if the bullying occurred as a result of something a teacher or administrator did or said to your child, the school district may be liable. In California, schools are required to have an anti-bullying policy, and they are required to enforce it vigilantly and in defense of every student equally. How do I sue a school district? First, you should consult an education lawyer and go over the facts of your case to determine your cause or causes of action. The most common grounds for suing a school district are negligent supervision, discrimination, sexual misconduct or harassment, excessive punishment or child abuse, bullying, wrongful expulsion, injury due to a hazardous condition, failure to accommodate students with special needs and disabilities, and employment-related disputes. In California, before you can sue a public school, you will first need to go through the school's own administrative complaint process, and you should do so with the guidance of an education attorney. How long does it take to sue a school district? Understand that suing a school district may take several years from the date of an incident to a final resolution in court. The timeframe may be shorter if the school or district offers a reasonable settlement amount to resolve the issue swiftly and keep the case out of court. Note that in California, you must file an official complaint with the school within 6 months of when you discovered, or should have discovered, that some type of personal injury, wrongful death, or property damage had occurred. After you file your claim, the school district has 45 days to respond. If your claim is accepted, the school district may compensate you accordingly, but most claims are rejected or unanswered. After the school district rejects your claim or refuses to answer it, you have 6 months to file a lawsuit. Or, if your claim was never addressed, you have 2 years to file a lawsuit. When should I contact an education attorney? You should contact an education attorney if your child has suffered harm or wrongdoing because of the action or inaction of school personnel. It is best to consult an education lawyer before you file an official complaint with the school, because what you write in your complaint will have an impact on the type of legal arguments you will later be able to make in court. It's important not to delay in taking action and retaining counsel, because there are strict time limits on how long you have to file a complaint and proceed with a lawsuit. Do I need an education attorney near me? We recommend finding an education attorney familiar with the school districts in the county where the case is being tried. An education lawyer in the same county as the school district will generally be more familiar with the civil courts versus an out-of-state attorney. Have any questions? We protect people like you every day. Email us at hello@educationattorney.com. Thanks for watching.